your kind introduction. You might notice that my voice is a little deteriorated, but don't worry, I took a corona test this morning, so it was negative. I can speak tonight to you and tell you about the following 5 topics. So first, I'd like to give you a little background and talk a little about the history of securities in Switzerland. Then we look into the first part of the new law. So the new law has essentially 3 pillars. The first pillar is tokenized securities. This is the most important one, and I will spend most of my talk on this one. Then the second pillar is what I call not your keys, still your bitcoins. So it means that you can give Philip from formerly Swiss Crypto Vault, now he moved position, but he built Swiss Crypto Vault. You can give Swiss Crypto Vault your bitcoins and they are legally still yours. And then the third part is the DLT exchange. So there's a new license type tailor-made for distributed ledger technology trading systems. And this is the third pillar. So the law enables 3 things. It enables the issuance, it enables the storage, and it enables the trading of crypto assets in ways that have so far not been possible. And then finally, I'll give you a glimpse at what the European Union is trying to do. They are trying to follow our approach, but they are lagging behind. So. Also, as a disclaimer, I'm not a lawyer, I'm a computer scientist and economist. So don't take this as hard legal advice. So if you actually want to rely on what I'm saying, ask an expert first. For example, you could consult lexer.ch, which is my brother's law firm. So you see here the law passed with all votes yes from the leftmost communists to the rightmost nationalists. Everyone liked it, so this is very nice to see. And I give you a quick timeline. So what happened so far? So the first draft law was published in 2019. Before that, there was even a consultation phase that Stefan mentioned. So then we commented on it publicly, and this is something that's actually very important and a serious part of creating laws in Switzerland. So a law can either be created by Parliament or it can be proposed by the Federal Council. And if the Federal Council proposes a new law, they have a public consultation phase which lasted for like 3 or 4 months here that enables everyone who wants to comment on it, and they take these comments seriously. So this differs a little from, let's say, Germany, when Germany revised its anti-money laundering laws, the consultation phase was only like 10 days, so no one could give a substantiated comment. But here we could influence the law, and some of our ideas made it into the law, which is very nice to see. So then they created a consolidated version by the end of 2020. Then in 2020, it went through the Ständerat and the Nationalrat, which is our 2 chambers, basically the Senate and the House. Here I could even present in one of the commissions of the Ständerat. I could give a 7-minute presentation to tell everyone why we are liking this law. So this was very nice, and they didn't do any real changes here, which is good news, because if the House did made a change, it would have meant that the Senate would have to vote on it again next year and so on. So sometimes laws, they get dragged out for 10 years or so because there's changes and another change and another change and so on. It goes back and forth. But this one had the final vote in, I think, end of September. And now there's 2 things that need to be done. For some parts of the law, there needs to be an implementing ordinance that specifies all the details. And the first draft of that has already been published and will hopefully be set into force by 1st of August. Maybe some parts will be set into force a little earlier, that's what we hope for, especially the parts concerning security tokens. But 1st of August is also a nice start. And here we are currently in the public commenting phase on the ordinance, where we also will file a comment again. Good, so now the real first part, share certificates. So certificated securities, like this share certificate of 500 Swiss franc from the Credit Suisse. They are the foundations of modern capitalism. So they were invented in the 19th century. I think the Dutch were the first to use it, and then the British, and soon after the Swiss and all the others followed. And they were used to finance our infrastructure. They were used to finance our banks and the railways and so on. So this was a huge success. And the essential ingredient that you need in the law is that the law needs to have a clause that says if you bind the share of a company to a paper, then the paper basically becomes the share. And that means the share inherits all the legal properties of the paper. It means you can transfer the paper and thereby transfer the share. And that makes it very convenient. It enables the trading of the shares of a company, which was before very cumbersome because there were centralized registries that you needed to update and so on. How is the acoustics? Is it? Do you all hear me? Good, good. So, and essentially this is a decentralized system, and the registry of the decentralized system is physical reality. So that system of paper shares uses locations in physical space to find out who a share belongs to. So if it's in Katie's pocket, then we can assume it's her share. So, and this is very similar to what happens on the blockchain, where we use the address space of the blockchain to locate a token or a crypto asset. Good. So here is a nice example of a prospectus to finance Hotel Victoria in St. Moritz. So this was a very common thing to have a prospectus, to publish it somewhere. Here it was a bond of 250,000 Swiss francs with a probabilistic repayment, which I find very funny. So there was a lottery to say who gets repaid and who not every year until it was paid back. And there was also things like coupon clipping, so you had to cut off parts of your share or bond paper to claim the dividend or the interest payment. So all was on paper. So the next step was registered shares. So as you might know, today we don't have bearer shares anymore because they are hard to track. So it's for especially to the tax authorities, they prefer the registered shares because here the company has a shareholder registry to track who owns each share. And you, based on this paper, you can actually see how it works. So here goes the name of the first owner of the share, and then whenever it is transferred, the current owner says who should receive it and signs it, and then hands over the share. And that's the transfer process. And then the new owner needs to tell the company, now I'm the new owner, please put me into shareholder registry. And this process is very important to understand because when you do it on the blockchain, it will be exactly the same. You have the same process. You have a blockchain-based transfer, and then you have a registration in the shareholder registry. So you have these 3 or 4 steps. You can and you can execute them in any order. So what you can also do, so lawyers are often very creative, or used to be very creative. I think today they might be a little less creative. But so what you can do, for example, you can say, I don't write the name of the new owner here, and I just sign it. That's a so-called blanco endorsement. So, and that means I can give the share to Stefan, and Stefan can hand it over to Armin, and then Armin writes himself in there and tells the company, and then he's the registered shareholder. So, and there's lots of nice tricks like that makes this a very flexible instrument, and still the company has a registry of all the owners. And there's also a very important rule that says in relation to the corporation, whoever is registered in the shareholder registry is deemed to be the shareholder of that share. So, for example, if Armin forgets to tell the company that he is now the shareholder, the company can still pay the dividend to the previous shareholder, and Armin is not allowed to complain. So if you forgot to register, you have no rights. And this gives you the best of both worlds. It gives you easy and fast transferability. You can buy and sell it faster than the company can update the shareholder registry. At the same time, you can give your rights, and you can get your rights when you need them, and the company doesn't have a risk of paying the wrong shareholder. So this is a small sketch how the stock market was organized legally until 2008. So the problem, of course, is if you have an archaic system, a paper-based system like that, how do you do electronic trading? And electronic trading was started to be very common in the 80s. How do you do that? And the solution, that's one solution. So here is also a big disclaimer. There's also other variants. I'm actually not entirely sure which one was used, but this is it was very similar to that. And the idea here is that you have a central depository that stores a share, and instead of having 1,000 certificates for one share each, you just make one global certificate that says 100 million shares. So just one certificate for all the shares. And you say, I hereby transfer it to, and leave the name blank. And then you store that in a central depository, and you say every client owns a small fraction of this share. And when client A of bank A sells his share to client D of bank C, then they update their internal accounting, their computer system, and just say, now one small fraction of this share moved from client A to client D, and they could trade the share without moving the share. Of course, this is kind of, it dilutes the original purpose of having a physical shared certificate. So it's a legal hack, basically. But it worked, so they could create electronic trading under Swiss law without changing the law. And then in 2008, lawmakers and lawyers said we need to have a more professional foundation for this, and they created the Intermediated Securities Act, which allowed to do this for the stock exchange, but we cannot really do this for traditional law of the small companies that are not traded, that are have not deposited their shares with the SIX exchange. So, and the question is, what do these other here is another slide again for the update of the shareholder registry. So here we maintain this split. So there's the central depository and there is the shareholder registry of the company. They might delegate the accounting here and the shareholder registry to someone else, to an intermediary, but in principle this is split. And the central depository tells the issuer which banks have its shares. The bank might tell the issuer who the actual beneficial owners are of the share, but maybe it does not. And these are so-called Dispo-Aktien, and for example, for a big company like Nestle, I don't know, like 40% of all the shares are Dispo-Aktien, where the shares, where the company doesn't know who the actual owner is. So the company just pays the dividends to the banks, and the banks distribute the dividends. So that's how it works at the moment. And also, this again is kind of a hack, and there is in principle, so shareholders might try to sue and say the issuer paid the wrong people because they are not even registered in shareholder registry. But no, so far no one did that. Good. So how do non-listed companies trade shares today? So if you own shares of a small company, you might notice that you never receive the printed share. And this is due to another legal trick. So there was a desire to say, we don't want to have the paper, we want to be able to move the shares around. So one problem with the paper share is the same as with cryptographic tokens. When you lose them, they are lost, and it's very hard to recover them or print a new one. So they said we will get rid of the paper, we will transfer it just by assignment declaration. And the legal hack that these two very clever lawyers conceived is the so-called aufgeschobener Titeldruck, which is postponed certificate printing. That means that when I create a company and issue new shares, and Armin is one of the owners, I say, you're now the shareholder of 100 shares, but I won't give you the certificate yet. And you agree to not demand the certificate ever. You have the right to demand the certificate, but you agree to never use that right. And when you actually move the share, you don't need the certificate to move it. You just reassign the right to demand the certificate to the next person. And so it's another legal hack that they use to make it possible to have shares without paper certificates, and that allowed this to happen. And this was later also codified in 2008, so that this is now officially possible in the law. And before it was just this legal idea how to do it. And this is, I actually kind of like this, that Swiss law allowed to create these new ideas without having to adjust everything fundamentally. So it was open enough, it left enough room for interpretation to innovate and to create new things that make sense. So, and if you look at these assignment declarations to transfer a share, it actually looks technically somewhat similar to a Bitcoin or other blockchain-based transaction. So an assignment declaration essentially says, I, Luzius Meisser, hereby transfer 5 shares of ABC AG to Hans Muster, and then I sign it. And that's it. So the recipient doesn't need to sign it. It's just me saying who gets it, and then I sign it. And as soon as I did that, the share is legally transferred to the new owner. By the way, if you have any questions or if you are unsure about anything, just raise your hands. So, and if you look at the Bitcoin transfer, it's actually quite similar. Here I say, I, owner of address ABC, hereby transfer 3 Bitcoins to address BCD, and then I sign it with the signature that, I sign it with the key that belongs to the address ABC. So, and interestingly, this clause, this assignment declaration, it sometimes gets forgotten. So I once saw a huge transaction, a double-digit million acquisition of a company, and a share purchase agreement was made by a reputable international law firm. It was about 50 pages, but they forgot this. So they had in there, the seller agrees to transfer the shares, or the seller must transfer the share, but they never said I hereby transfer the shares, or the seller transfers the shares. So they forgot that clause. So after we signed everything, we noticed the shares are still with the sellers, and then they had to demand some more signatures from the sellers. So it's easy to fix. You just they need to sign again something else, but it's common that there are mistakes, and if there is a mistake and the whole chain of transactions, and the first transaction was wrong, all subsequent transactions are also invalid. So it's actually kind of a risky system. And I'm involved with one startup where we looked at all the past transactions, and we found a lot of stupid mistakes. Like in one case, someone didn't actually sign a paper, but copied his signature into a PDF file, so the picture of his signature. And that, of course, is not a formal written statement, so it wasn't a valid transfer, and we had to get in touch again with the person and say, please sign a... Yes?
One question, I mean, here you say, I, Luzius Meisser, hereby transfer shares to Hans Muster. The difference is that here you know to whom you transfer the shares to, and there's a dedicated recipient. Whereas on Bitcoin, you can send it to anyone, you don't even have to know the person.
Yes, this is very important. And I'm showing you this because this was my first idea of how it could be done. So I wrote an article in NZZ in 2016 and said, this looks very similar. So maybe, I basically, it was about the potential of the blockchain. I said we should use the blockchain for trading of securities, and we could transfer these securities if we change the law, because the law says if you make this assignment declaration, it has to be in written form. And of course, it's not in writing if you do a blockchain transaction. So I said maybe we could fix that and unleash the potential of the blockchain for securities trading if we get rid of this Article 165. And for exactly the reason you said, I was on the wrong track. So this was good that I suggested this, and this was discussed because it created discussion. But in the end, it's a token transfer on the blockchain is actually more similar to the transfer of a paper. Because, and this is the crucial difference. So even if you could say we just use digital signatures, but the traditional digital signatures, they prove something else. If you use an electronic signature, you prove who you are. But on the blockchain, when you sign, you prove that you're authorized, and that's not the same thing. And that makes it much more similar to the paper-based system, because with the paper, you also don't prove who you are, you prove that you're authorized because you have the paper. And that's, fortunately, so they followed this approach. So when, so we are now getting into part 2. So there's at the, it was very nice to see there are lots of very competent and very hardworking people at the Federal Council that created in a relatively short time a very nice law that is more or less, so they copied lots of concepts not from the law on the assignment of claims, but from the law on paper securities. So they used, as a template, they used the characteristic of paper securities, and this is the right choice to do. And so this might be so the most essential slide tonight, so because there's really the core content of this law, where it says what security token actually is. And this is very challenging to do as a, so if you write the law, it should stand the test of time. So in 50 years, this should still make sense. So you should not use buzzwords like blockchain or so, but you still should get to the essence of it and describe what needs to be done without being too broad and too general. So, and this was a very interesting process, and it's nice to see what the result is. So in the end, so what does this say? So it calls these security tokens registered Wertrecht, or it's a registered security basically. I call it security tokens in the translation for simplicity. So what is it? So it's something that's recorded in a registry according to this part of the law. And I will go through this one by one to see what it exactly means. So the first important thing is that this right that is bound to the token, it could be a share, it could be a bond, it could be anything else that the issuer issued, it can only be claimed through the registry, through the blockchain. So it's like with the paper share, you can only claim to be the owner of the paper share if you hold it in your hands and if you prove that you are the owner. And this is the same here. And then, so of course, instead of register, what is meant here is blockchain and so on, without using these words. So what's also interesting is, and this is was a discussion internally, so can you transfer a security token without changing anything on the blockchain? And essentially the question is, could you do this for a share? So this is a paper wallet with 1 Bitcoin on it, issued by Bitcoin Swiss. And let's say instead of 1 Bitcoin, I would have 100 shares of Bitcoin Swiss on this paper. And then would it be legally valid if I give it to Stefan? Would he now be considered the owner of the share, even though we didn't change anything on the blockchain? So, and in the initial drafts of this law, this would have actually not have been considered a valid transfer. It said you need to do the transfer through the blockchain, which is, but it's not. I think it's not the right way to do it. So and they improved it, and now it's the condition is that you need to be able to prove through the blockchain that you are the owner, but the person that can prove that might change without having a visible change in the register itself. So it's a very yes.
This basically means if someone steals the private key with access to these security tokens, he's then
Yes, it's just like stealing a paper share. If you steal a paper share, you have it. And then, of course, there are legal ways to claim it back. And we will come to other interesting properties in that connection. What happens if someone steals a share and then sells it to you and you didn't know that it was stolen? So, and here, so what conditions, so what are the requirements that the law imposes on the blockchain that is used to have this, these crypto assets? Or it could also be the requirements for the smart contract within that blockchain. So what requirements do you need to fulfill? And here the first very important requirement is that it provides the owner, but not the issuer, with technical methods to transfer and dispose of the tokens. So the technical methods here are, what's meant here is cryptographic signatures. So doing a cryptographic transaction is a technical method to transfer it. And the important part is that the issuer should not be able to transfer it. And this is to protect the shareholder from the issuer, to have the right balance of power. So, and it also, the same is the case for a paper share. The issuer cannot destroy your paper share while you have it stored at home. And this is something that is violated if you build in an admin backdoor into your smart contract. So sometimes people say we need to have a backdoor in the smart contract to recover tokens or to freeze them for compliance reasons and so on. And if you do that, you are most likely in violation of that law, and you are not creating a valid security token under the new Swiss law. So you should refrain from putting a backdoor in there, because as soon as the backdoor is in there, your registry is not much better than an Excel sheet, because the issuer can change it at will, right? So that's the, yes?
This means that USDC or Tether, they are not really legally based on Swiss law.
I'm not sure about Tether, but I think USDC has kind of a freezing function in there, and of course there's some wiggle room there. So it just says the issuer cannot change it, but maybe you delegate it to a bank who has the backdoor key. I don't know what the judge will say then. Or maybe we have in the crypto franc with a pause function, which is also kind of critical to be able to pause the whole contract. It makes sense in case of a fork, but I think I wouldn't put it in there again. And what's also unclear is what it means for contracts that can be updated. So sometimes tokens use proxy contracts that today don't have a backdoor in there, but that could be updated at any time to contain a backdoor. And here so there's no legal opinion on that, how that would be valid or not. And I would say that as long as you don't put in the backdoor, it's fine. Even though if you have the you can have the capability to do any kind of updates, but again, I wouldn't encourage it, because if you can update the smart contract to anything, whatever you want, then the rights of the holders are not as enshrined as they should be. So there's lots of interesting legal questions there, and this is all left open for interpretation. So this is again the beauty of Swiss law. They resisted the temptation of being very, very specific. And the problem is when you're too specific in the details, you get it wrong all the time, because you cannot plan innovation. You cannot see ahead. What you need to do here is to say, we leave that open. And if there is a dispute, we let the courts decide, because the courts, they can see the actual case, they can see the context, and they can make a much better decision than we ever could years in advance. How could we decide what the right choice is for a specific case in 20 years? We cannot. So that's why it's the right choice to leave it open. This might be the most controversial thing, that the issuer must not have the power to move the individual tokens. So then it says there must be appropriate technical and organizational measures to ensure that the registry is protected from unauthorized manipulation. And this translates into you cannot just use an Excel sheet. You must use some technical and organizational measures. And organizational measures means, for example, that even if you have a technically secure network, it doesn't help you if all the nodes are run just by Swisscom. So you need to have different entities running the nodes. It needs to adhere to a certain standard of decentralization. And again, there's no specification about what that means. Is 5 nodes or 5 entities enough? We don't know. But you better be on the safe side, yes?
I have one question to the previous point. One possible or one proposal to ensure that not the issuer alone can dispose over these security tokens would be that you could split this possibility to dispose on 2 independent players or actors. What would these actors be? Like the issuer and the
yes, so clever question. So what if the issuer says we have a multi-signature scheme to recover tokens? And again, the law is open on that. Maybe you get through with it, but if you have a relationship to the other entity, if it's just your lawyer who does anything you pay him for, then it's probably not decentralized enough. So, yes, so this essentially says you need to have a secure system, you need to have something as secure as a blockchain. And even a permissioned blockchain might not be secure enough if it's just run by one legal entity. So, and the next thing, this is an interesting one, and I think this is the only term that makes current standard ERC20 tokens not compliant with this law. It says within the smart contract there must be a link to the documents that describe what you are buying. So that means, so I copied some code in here. Usually in an ERC20 contract you have a name and a ticker symbol, and what you need to add here if you want to be compliant with an issue under Swiss law, you need to add a user-readable string that links to the terms. So it could be a link to a website, it could be a hash key of a document that can be easily found through that hash key. But there must be a way for whoever buys the token to look at the token on the blockchain and find out what the token actually represents, that it is a share of this company and what the terms of the issuance were. So, and I think this makes sense, and this is a good addition. And it's also easy to do, and maybe you should also have a function to update the terms. Maybe you change your website and have a new link. So the important part, it doesn't need to be constant. So you can update the terms within the law, of course, and you can update the link.
What is the idea that the information there is like in a prospectus in an IPO, or is it more legally and technical?
Yes, it could be linked to the prospectus. So what they say is die Registrierungsvereinbarung. So maybe you should also have the articles of association available that give you the foundation to issue these security tokens, just the formal documentation to create the shares. So it's nothing new, it's all existing documents, but you must make them available. So, and then this is an important one. This mainly concerns permission blockchain. So if you run all of this on a permission blockchain, the user must be able to download all the entries on the blockchain that concern him and verify himself that the integrity is given, so that there was no manipulation or so. So this technically it more or less means that everyone must be able to download the current state of the blockchain and verify that everything was done correctly. So there might be, so I quickly thought there might be a problem with pruning. So pruning is when you delete old transactions, but I think if pruning is done in a reasonable way, like if it's 1,000 blocks ago, then it's still okay. Good. So, so this is basically the core of this law, and I like it a lot. So I think it's very elegant. I think they captured the essence of what a blockchain is and what properties it should have.
Yes. And your point number 3 about the for me this is kind of strange because obviously today you have a new set of law in place or place soon. How can you now say everything backwards is not legal anymore? So you also need a certain confirmation of the past. So would this really mean that historically published smart contracts are not valid anymore?
So the question is, what happens with historic old already, like the crypto franc that are already out there when this law gets into, is set into force? And the answer is nothing. This law adds a new possibility to create security tokens on a clear legal foundation. For all the old tokens, we have the same legal uncertainties as before. So it's the old tokens, they don't benefit from the law, but they also don't get hurt by it. And of course, my recommendation would be to find a way to transition to the new type of token, because then you have all the foundation and interesting properties like the following one. So the following clauses in the law, they're about giving these tokens the same properties as physical shares. And so one of them is that the issuer only needs to honor the rights of those owners who can actually show the token and prove that they are the owner. So these are simple things like this that make it really behave like a paper share. Another thing is good faith acquisition. So this goes back to your question. So what if I steal a share from Stefan and sell it to you? So this says if you buy it for a fair price, if you have no reason to suspect anything, you can keep the share and Stefan cannot go to you and demand it back. And this is very important because it means that you can buy shares on exchange, and if you do so in good faith and everything, is you can keep the share and there's no risk that you have to return it to whoever had it before if it turns out to be illegally acquired sometime before. So it protects the integrity of the market.
But I mean, it depends a bit, right? I mean, there are these cases where there was some hacker stealing some funds from an exchange, and then these tools from chain analysis and so forth sprang on this, and then other exchanges were informed about it, and hence they blocked any tokens that related to this hack from being accepted on their platform. So this is something that then also needs to somehow be in place, no? That you allow for this to happen, actually.
So if you know, if you have the information and the technical capability to find out that these shares comes from a hack, then of course you are not allowed to buy it. Then, or you risk that someone demands it back from you. So, and this is, these principles, I think they go back to the Roman Empire. They start to figure out how to deal with all of these situations with physical things. So, and this is an interesting one. So, it was very hard to actually define what is a transfer of one of these tokens. As I said before, you cannot write the transfer is done by changing something in the register, because now, if I get this share back again, so we should have transfers like this, where that happen indirectly. And so what it says now is just the transfer of tokens is governed by the rules of the token terms. So what I would recommend is to put into the token terms just to say something like the indirect transfer is also possible. That means that if you issue a token and someone wraps it into another token, so you have wrapped Ether, but you can also have a wrapped other token, that transferring the wrapped token is also valid transfer and so on, or transferring a paper wallet is also valid transfer and so on. Because otherwise it can get very messy. Good, and here is the, so before we get to the more pictures and so on, one last very text-heavy slide. So what if you lose a security token? And here it's oriented again on the paper share. When you lose a paper share, it's a cumbersome process. You have to go to a judge. You have to convince the judge that you lost it and owned it before, and then he can declare that this share is invalid and you can demand a new one. And here the process is the same. If you if a security token gets lost, you can go to a judge and demand it be declared invalid and get a new one from the issuer. But it's nonetheless it's good to have a recovery mechanism, and we have actually figured out a recovery mechanism for such cases that is decentralized and doesn't rely on a backdoor. So to summarize, if this is the old world where you have a paper share, when you transfer it, you update the shareholder registry, and this is the new world where you transfer a token, and afterwards you update the shareholder registry. And this is, I put this here to illustrate again that there's no need to put the actual shareholder registry onto the blockchain. It can be an Excel sheet, it can be a piece of paper, or it can be a database, which I would recommend, but it doesn't need to be on the blockchain, the shareholder registry. All that needs to be on the blockchain are the tokens that represent the shares. And of course, I've always talked about shares now. If you issue something else, if you issue a payment token, for example, there's no need to have a registry. Or if you issue a bond, it could be a bearer bond. There's no requirement to have a registry, and then owners can just freely transfer it. And for example, in case of a payment token, you would then identify the clients on issuance and redemption. And then you also need to do KYC and so on. But it generally, the rules that apply, the compliance rules that apply depend on the type of the token. And they are the same regardless of whether you use the blockchain to issue whatever you're issuing or whether you're using a traditional paper certificate. Good. So that was part 2. Now we are speeding up the next 3 parts. They're very fast, just a slide or 2 each. So not your keys, still your bitcoins part. So today, if I store this Bitcoin for Stefan, then it's still legally considered his. But if I store many Bitcoins on the same address, that's not the case anymore. But if you run a custody service, it can be very beneficial to have deep cold storage with thousands of Bitcoins that you never touch and that are shared, at least virtually, between different clients. And this will be enabled in the new law, so it will become possible to store the Bitcoins of many clients on the same address, and they will be still legally considered to be owned or belong to the client. And this is very important. It means that when the Bitcoin vault goes bankrupt, today only this client could get his Bitcoin back, and everyone else would suffer from a haircut and would share the proceeds of auctioning these Bitcoins off with the other creditors. But under the new law, all the clients could get their shares of the stored Bitcoins back. Of course, assuming that they are still there. If they are not there, then they don't get anything. But if they are still there, they get them back. And for this individual case, here again, Swiss law was very open, and there was room for interpretation in both ways. So there was room for interpretation to say you can already do this under current law, or you can't do any of this. And FINMA chose the middle ground and said this is already possible under current law. And I put a thank you to FINMA in here, because this is not often they tend to go with the strictest, most interpretation of the law, but here they were very nice and said this is okay, which also makes sense. So it allows businesses like Bitcoin Swiss to store lots of Bitcoins for its clients in a secure manner. And the clients know that the Bitcoins belong still to them, even if Bitcoin Swiss goes bankrupt, and they don't have to share with other clients.
Share request, you need a bank license, and it's segregated, you don't.
Yes, you already read what the new law is. Yes, so
That's incredible. Such a small change, and you don't have to get a bank license.
Yeah, so yes, so the current situation is as soon as you do the collective storage, this is considered a bank deposit, and then you need a bank license. And the new law says we recognize this as still belonging to the clients. So it's technically not a deposit, it's a storage. And that means you don't need a banking license, but we introduce a new licensing requirement, say you need a fintech license, which is a lighter type of banking license. And this is, I advocated in our statement for saying it should be the same. Everyone should be able to store Bitcoins in both forms without a license, but there was lots of pushback. Some people wanted to say everything needs a license. If you store Bitcoins worth $1 billion, you need a banking license. You're essentially bank. So this is the compromise in there. So but there's 2 exemptions. So one is you have 60 days time to segregate it. So you can accept the funds, have maybe a small Tageskasse, a daily address that moves in and out, and then you have 60 days time to segregate the client assets. Still, I think if you operate a storage or a brokerage, it's good to have the ability to pool them. And so in the future, some Bitcoin brokers might think it's a good idea to go for that fintech license. We will see. Good, so now the 4th part, which is the 3rd pillar of the law. It introduces a new license. So today, if you want to create a new securities market, let's say you have a completely new type of securities, new technology, and so on, you need to replicate all of these things. So first, you need a bank. If no banks works with you, you would have to create your own bank. Then you need the exchange itself. But the exchange itself can only match the trades. You might need a central counterparty, depending on what is traded. You need a security settlement system. This can be run by the central depository that actually stores the shares. And you need a payment system which can be run, for example, by a bank. If it's not, it needs a separate license. And then you need a transaction registry to register and monitor all the transactions. And each of these are separate legal entities that need a separate license. And each of these legal entities, they have some requirements. They need a board that is independent of the management, and they need an internal compliance that is also independent of the management, and they need an independent place where people can complain, and they need an internal revision that's also independent. So, all of these organs need to be staffed by qualified people that are verified by FINMA. And if you have to do that for like 7 legal entities, and all of them have capital requirement of at least $500,000, then you see it's very, very costly to create something new and to create an exchange for tokens. The idea of the old law, of course, is that if you want to create an exchange, you just create a new exchange and you reuse the existing infrastructure. And the law also says all these, they are required to give you access. So they cannot say, we don't want you to compete. So by law, they are required to give you access. The problem is they are not required to store your new kind of token. So if you want to have an exchange for security token, SIX or whoever runs the central depository in that country can say, we don't store that kind of assets. And then you still need to do all of that on your own. So what they did, they create a new DLT exchange license, and this DLT exchange is allowed to have retail clients directly. So you don't need to have a bank in between, and you can also run everything you need yourself. And there's different types of licenses. So the simplest license is just the 73A license. This is essentially an exchange that says we just run the order book, we match the trades, but we outsource the settlement and payment and everything to the blockchain. So they prepare a transaction, they match people, and then they let the trade be executed on a public blockchain, for example. But you could also run an exchange that has a central depository. A central depository essentially is the original place where a share is registered. So if you just if you receive some ERC20 tokens and store them for your clients, you're a depository, but not a central depository. So this is when the issuer directly issues the share in your system. then you're a central depository, and that triggers additional requirements. The same is the case if you are settling, having a settlement system. And here there's a very interesting legal question. So with a blockchain-based system, you can do atomic settlement. You can say the payment and the share that is being traded and the agreement on the trade, all three happens at the same time or not at all. And that means your settlement, there's no settlement actually. So the trade is the trade, and there's no settlement period, and there's no settlement risk. And in such case, one could argue that if you do atomic settlement, that you don't run an actual settlement system and you don't need to fulfill these legal requirements. And this is one of the open points where we take the position that if you do that, you don't need to fulfill these requirements, which don't make sense in that case anyway. So, good. So this was the last part. One important point here, by the way, is where we need to file our comment is they also adjusted the money laundering law a little, and so far what made you a financial intermediary is having access and being able to move client assets. So if you can touch client assets, you are a financial intermediary. But now they are trying to revert it a little and saying if you enable the transfer of assets, then you're a financial intermediary. Yes?
How is the, I mean, regulation tries to get hold of entities, legal or personal entities, but with DeFi you don't have these entities. So did you have some discussions around this, or how in the whole process was the topic of DeFi, where you don't have a legal entity that you can go sanction or sue? Yeah, how do you deal with that in the regulatory?
If you have no legal entity, then no one is responsible. No one has the AML duties and so on. Like Uniswap is outside of this law. It doesn't require a license. What's also very nice is you don't need a license if you run an exchange non-commercially. If you don't do it for profit, if you have only a limited number of clients, then you can actually. This could be, for example, a company that creates a trading system for its own shares, so the employees can trade their shares. So then it doesn't need a license. And this is very nice to have this exemption. Yes?
Isn't one problem that in order to run an exchange in Switzerland, you need a business entity that is operational in Switzerland? And this is why decentralized exchanges cannot be regulated or do not fall under the scope of the Swiss law?
Yes. So yes, if you have the decentralized exchange, you cannot say it's operated in Switzerland. It's
exactly.
decentralized.
Why it doesn't fall under the scope?
Yes. It's of course as soon as you have some administration possibilities. So there's, for example, Kyber Network behaves quite a bit different than Uniswap. Kyber Network, they decide which tokens are being traded and which are not, and this gives them already a lot of control, and that's why they are fearful of allowing security tokens, whereas Uniswap allows anything because it's truly decentralized. So if you want to create a decentralized exchange, you should make sure that you don't have too much control. Because otherwise you are operating it, and that makes sense. And I think it's also a fair way of regulating things, because if you're doing a truly decentralized thing, then it's kind of a non-profit almost, like Uniswap. They will have a hard time at finding a business model to extract a lot of money from the traders. Good. So now the last part. So the European Union, it's interesting to see what they're doing. You know that Liechtenstein was a little ahead. They were first, but I think the Swiss approach is a bit better and better, so true. I prefer the Swiss approach over the Liechtenstein approach. And now the European Union has announced various initiatives and proposals to do similar things. And one of them I list here is their proposal for creating. Actually, I copied the wrong text here. So this was the name for the sheets you see here. This is for their pilot regime. They essentially want to create a DLT exchange They call it a little differently, but it's the same idea. So the reason why we had to do this change at all is that we copied the European law with the Financial Markets Infrastructure Act to be compatible with the European exchanges. And so before that, no changes would have been necessary at all, because up until 2016, we had a very nice clause in the exchange law that just said if something new is coming up, the Federal Council can regulate it as ever it sees fit. So they would have had complete freedom to allow guilty exchanges. But then we copied the European approach, which provides a framework for the financial markets. And I actually hate legal frameworks, because a framework by definition disallows you from thinking outside of the box. I think laws should provide foundations where you are free to build as high as you want, and they shouldn't provide a framework, because a framework typically only allows what's inside that frame, and thereby by definition limits innovation. And that's also why these laws, they need adjustment whenever there's new innovation. And one thing I noticed here, and this is over the time while looking at these different laws and working with the Swiss law, I became a bigger and bigger fan of the Swiss approach, and I grew more and more skeptical of the European approach. For example, you see, they regulate the same, what we regulate on 6 pages on like 45. And I have a long Twitter rant on this and another EU proposal where I criticize them because they also often get priorities wrong. For example, one of their highest priority is harmonization. They say it's very important to have it everywhere the same. But if you have a regulatory monoculture, you harm innovation, because innovation needs experimentation. You need to have variation, you need to have different approaches being tried out in different countries. That's the only way to find out what works best. But if you harmonize from the beginning, you might destroy a lot of potential without ever finding out. And that's why it's so important to have different approaches and to have an open foundation and not a restricting framework. So I greatly appreciate the Swiss approach, and we are now open for questions.
Coming back to the Registry Securities, which we talked about in the beginning, for me it sounds a bit like these are basically bearer shares in the end, because I can freely transfer them until I want to have the dividends, but if I don't want to have the dividends, I never have to tell someone who I am, right? But bearer shares are forbidden in Switzerland for like private companies, so there I don't see how that fits into the current legal framework.
So they are essentially the same as current named shares. So named shares in Switzerland work exactly like this. If you have a printed named share, I can give you the share, I write your name on it, and then you notify the company. And you have the obligation to notify the company, and if you don't do, your punishment is that you don't receive any of your rights. You don't receive the dividend, you don't receive voting rights, and so on. So the idea is that the share remains useless. And in comparison to that, a bearer share is something that you can just bring to the General Assembly and say, here I have the share, please give me the dividend. And you don't need to identify yourself. So the crucial difference, why this is not a bearer instrument, is that you have to identify yourself in order to make use of your rights.
But the thing here is, I think that I have a token, right? So even if I say I don't want to go to the General Assembly, I don't want to have the dividends, I still have a token which I can transfer and which could have a value, maybe in a secondary market, in a black market, whatever you want to call it. Whereas a named share in Swiss law, now there's no paper, there's nothing to represent it, so you cannot transfer it because you cannot assign value to anything.
So the question is again, what is about when you make capital gains without ever registering? And this is, you can do. You can also do today with the named shares. You can buy the share, you can have the share certificate. So if a company prints share certificates, which they can still do, even if there's no printed certificate, I can sign an assignment declaration and transfer 100 shares of Bitcoin Swiss to you. And if you don't notify the company actually doesn't know that you are a shareholder. And maybe you can assign it to the next person, and then the next person registers with the company. So that's how registered shares work in Switzerland. And it actually makes sense because, so let's say you say the requirement is that everyone needs to register. Then instead of transferring the share, I could just sell you the option to buy the share from me for 0, right? And then economically you have the same. Economically you have an instrument to participate in the capital gains of the share without having transferred the share. So this is, I guess this might be the background, that even if you require the immediate registration, which would be in many cases a huge pain, and rule out things like Uniswap, because you cannot, who do you register if you move a share to Uniswap? You can't register a person because it's a decentralized entity. So if you would make these very hard restrictions, you would destroy a lot of economic value, and that's not, I think that cannot be justified just by the need to know who that person is, because it's so easy to circumvent. So I think the right way to do it is to attach the incentive to register to the dividend rights and other rights. Also, in case of the blockchain, you might want to be notified when something happens. So I built, so this is the very last slide. So I advertise here my latest company. We build tools to enable all of this. And one thing we do is we send out notifications. So if you use our tools and you are a shareholder, you get a notification when your shares move, for example, or when you receive shares. So you can see what happens. And these are, I think you get a lot out of it if you register. But still, of course, as an issuer, you will never be sure whether Osama bin Laden owns one of your tokens. But that's the price of having a free system with free transactions, and that gives you much more than the damage done by sometimes someone you don't like owning a share.
I like it a lot. I just think it's super counterintuitive to the current AML discussion and everything we have around preventing exactly that free flow of transactions.
Yes, so this will be interesting to see what the future will bring, because the current AML laws, they're all focused on the intermediaries, and if there's no intermediary, there's no AML duties. So we are currently in a very free world, and we should use this opportunity to show that we can create value in such a free world. Yes, and I think if all of this is used for good, then we will have a lot of public support to keep it as free as it is today. Any other questions? Yes?
You said this very critical point that the issuer cannot move the shares. But also today, if somebody loses its share, the issuer needs to be able to call it void and issue a new share. How does that work with a token? And in the end, isn't that the same as being able to transfer as you burn and issue a new token?
You never burn the old share. So the question is, what happens when a share gets lost? What happens to the old token? And if it's lost, so then you just leave it there, because if it's truly lost, you don't care whether it's on an address forever or whether it is burned, right? Maybe you should have a function where you can adjust the total number of outstanding shares, where you can say there's 1,020,000 outstanding tokens, but actually there's only 1 million shares because 20 of these tokens are invalid. But you shouldn't be able to immobilize these 20 tokens.
Can't you today say share certificate number 23 will be deleted from the registry?
Yes, today you can delete you can also delete it in that case from the shareholder registry, and you can make a public statement, say share number 23 is invalid, but the certificate, the paper certificate of share number 23 still exists somewhere.
No.
So, and this again, it's so good to have this analogy with the physical share, because everything works out very well. And all these questions, they have been answered for physical shares before, and we can now provide the same answers again.
How do we see the development in the tokenization world in 2021 until the law is kind of in place and yeah, kind of finalized? The development of smart contracts. What kind can we expect in the adaptation of the new needs here for Switzerland?
So I hope, of course, that lots of companies will try this out. So for that, they need a tokenization provider, and there's a few variants out there. There's also the Montpellier solution, for example. There's the CMTA, that's the Western Switzerland Association that put out a standard on how to do this. So there's different competing approaches out there, but they will essentially do the same in the end. And I think that tokenization itself will be a standard commodity service, and the question is, what do you sell on top? And what we try to sell on top is the creation of the market. So how do you create a nice smart contract, maybe Uniswap style, to sell these shares directly to the clients on the website? If SIX does all of this today, why don't they just switch to this tomorrow? That's the question. And the answer is there are some restrictions in there. So this is only for security tokens. You cannot trade traditional shares. Another restriction is you cannot publicly list shares. You can only publicly trade shares. And so this is only a legal difference. Technically, it's exactly the same. But legally, there's the kotierte Aktien and the listed Aktien. So the ones that are officially listed, they have somewhat higher requirements. They're often a little larger companies, and they can very easily be bought by pension funds and so on. And if you are not officially listed, you are still freely tradable, but not everyone can buy your shares as freely as before. So it's a question of accessibility. And this is one restriction here. You cannot officially list shares. In the current draft of the implementing ordinance, there's also other restrictions. One draft restriction is you cannot trade derivatives, which I think it kind of makes sense to don't give clients access to 100x leveraged bitcoins, because that's essentially gambling. But still, it might make sense for some other derivatives to allow them. So the question is also, what is a derivative, which is it's kind of open. Yeah, so the question is how that relates to gambling, where gambling is allowed, and why should we even outlaw people from wasting their money? They should be free to spend it, right? So I think it's been historically grown that way. And for example, Zwingli here in Zurich, he was very tough on gambling. He made sure it was outlawed because he said it's a sin. So there is some moral component in it. And regarding the gambling, so gambling is also very strictly regulated. So and there are things you're not allowed to do, and you have to share profits with the taxman, and with often it's with non-profits that do nice things in the end, and you have to monitor all. So if you have to monitor who spends how much, and you have to prohibit people from participating if they spend too much of their money. So it's risky gambling, and it's also heavily regulated. And I recently received a phone call of a senior citizen who once listened to one of my presentations, and he said he lost like 90,000 Swiss francs with currencies trading. With not even a Swiss. So there's these companies out there that try to lure in citizens. They promise huge gains, and then they lose everything. And it's and this, of course, this hurts me to hear. Yeah. And then I think maybe it's not a good idea to offer these kind of services that do not provide that much value in the end anyway. So the foreign exchange market is so efficient. I don't think it hurts the market much if you don't allow this leverage gambling where they can, with these binary options or whatever, lose everything within a minute. So it's because in the end, if a person loses everything, it's the government again who has to pay to make sure he still has a living, right? So that's the reasoning behind it. So I'm always on the side of trying to allow more, but I can also see why people are skeptical towards derivatives if they are suitable for making people lose all their money within a short period of time.
In view of the simplicity of this DLT trading system, do you think that we will see a trend towards tokenizing like blue chip shares, so that they will be traded as tokens rather than on the legacy?
So there is one more license which I skipped here, and that's the organized trading system. And this is even simpler than that, but you have to be a securities dealer, and then you can run an organized trading system. That's, by the way, I think Signum announced to do that. And then you can trade anything. And the restriction is it has to be a bilateral market. This is a dealer's market, essentially, where people don't trade among each other, but always trade against you. But of course, you can always say, you trade with me, and then I trade with you, and then you have essentially traded among yourselves. So I think this was put in there by banking lobbyists when the new financial market infrastructures law came up, because they were running exchanges for a long time for small shares like NZZ and so on. And under the new law, under this law, all this trading of the small Bergbahnen would have been rendered impossible. Yeah. So this organized trading system, as it is in the Swiss law, it enables to continue this kind of trading, and it's currently the method of choice. And I've heard something very interesting. So when the Swiss copied the European approach, so they picked the British translation of the European directive, because there the organized trading system had a slightly different meaning than in the German version. So, and it was more open to allow these kind of things. So it's even in European law there might be differences, and the Swiss exploited that by saying we are compliant with European law, we copied just the English version. Well, I'm not sure if true, I just heard that. It sounds fun. Yes?
Sorry, it's me again. The text you showed said that you're only allowed to pay out dividends as an issuer to someone which registered the share with you, right? Is there like requirements how you can prove that you're actually the owner or can use the private key? Because even if you tell me that you are own the share and I pay out to an address, how do I make sure it's actually you and not your friend, but you just said it's you?
This is again very elegant. There's no strict legal requirement on how you verify this. But if you, as a board of directors, start to pay out dividend to wrong persons, you become liable. Because then those who should have received the dividend can come to you and say, pay me.
So, and with your new venture that you showed, how would you implement that? Or have you already thought about that as an issuer?
No. It's, at the moment, we just trust whatever the shareholders say. If they say that's my address and my name, then we put that into the shareholder registry. We automatically update the shareholder registry. And the current working assumption is that the companies we are addressing, they're rarely paying out dividends. So it's also there's no dividend paying functionality in Aktionariat yet. So, but it's of course we need to solve that sooner or later. And
so there's the company that is Island Token. Yeah. There you need to sign a message that I declare that I bought these tokens on this address and this is my address, and you sign a message with your private key, and then you get entered into the registry.
Yes, so the private key verification, we have two. But of course that doesn't prove that you are really Bernadette or whoever, so you don't know if they provide the wrong name, so there's no verification for that at the moment. And of course what you could do, you could say we pay the dividend by bank transfer. and then you see the names in the bank transfer. Of course, that's not the point of the system. But what you can also do, if you pay the dividend to the address that is the current registered shareholder, there's a very low risk that this is the wrong person. Then, of course, the risk is only that the only risk is that the person provided the wrong name, and the previous shareholder says you shouldn't have paid that person because that's the wrong name. But how does the previous shareholder find out that you paid, that the other person didn't register correctly? So I think it's unlikely that a lot happens there, and for the large amounts, you probably, so the large shareholders you know anyway. So most companies, they have a personal relation, especially if they are not listed on the stock market, they have a personal relationship with 90% of the shareholders. So this also limits the risk. But it will be an interesting question to figure out and see what happens. Another risk, of course, which I didn't touch, is what if an American buys your shares? Because the United States tends to apply its laws all over the world. And for example, if you make mistakes in your reporting, you might get sued for securities fraud in the US because someone might have sold his shares based on your mistake and made a loss. And so then you might get sued there. So it's also when you make these shares available internationally, you need to make sure that you observe all the local prospectus duties and so on. The financial sector is heavily regulated and can be a minefield, especially when you try out new things. The question is, could you restrict who can become a shareholder? And so Swiss law has something called Vinkulierung. So you can put into the articles of association some limitations of who can become a shareholder. And then you can refuse the transfer for these shareholders. And one example is NZZ. They have a restriction. They say only members of the FDP, of the Liberal Party, can become shareholders of NZZ. So, but you can buy the share. You can buy the share on the market, and it's in your portfolio, but you won't receive a dividend. And if you request registration, they will refuse it if you don't show proof that you're a member of that party. But generally, it's the way you can limit this is very limited. So, for example, you are not allowed to use this to enforce a shareholder agreement. You cannot say only people who signed the shareholder agreement can become a shareholder. And it's probably also very problematic to say Americans cannot become shareholders unless that poses a real risk for your company. So you would have to show that US law is so toxic that it would be an unbearable risk to have American shareholders. And then, of course, you need to find out how do you enforce that. And I think the blockchain is not very suitable at enforcing this, because I could always use a paper wallet and send the paper wallet to the United States. And then, so you then, of course, can refuse the entry in the shareholder registry, and maybe you're less liable, but it's it's not an easy question, and it's again something that will make lawyers happy probably when people start to figuring out how to do this. Yes. So the question is if you could use a digital ID. Yes, you could, but you would then severely restrict the transferability of the token again. It wouldn't be possible to trade it on Uniswap anymore, because Uniswap doesn't have such an ID. So I think this is a misguided approach. So this is open for discussion. Some people say we want to make sure that every address belongs to a known identified individual and ensure compliance through that. But I think this is the wrong approach. I think transferability and compliance need to have distinct solutions. These are separate concerns that need to be addressed in separate ways. For example, when you want to freeze funds, this only applies when the token is resting with a financial intermediary, and then the financial intermediary has control over the funds anyway. So there is no need for having a freeze function in a smart contract. Good. So the idea was to have a little longer discussion than usual, so people don't mingle too much. But I think it's been 1 hour and 20 minutes. So if someone has an urgent question, one last question.
Just the last one.
Yes? Yes, so very good question. So the question is, are they allowed to trade tokens that are not complying with all these rules we've seen before? So, and the answer is yes. The only thing they cannot trade is traditional securities, but they can trade Bitcoin, they can trade all kind of crypto assets. One exception is privacy coins. So for money laundering concerns, so Monero and Zcash wouldn't be allowed. But everything else is possible if it's in accordance with your own articles of association and the regular. So like a real stock exchange, a DLT exchange must define criteria. They must define everything we list must at least have a market cap of whatever, and the issuer must be transparent about whatever matters and so on. So there needs to be a list of criteria, and this list of criteria needs to be approved by FINMA, and then they can approve anything that conforms to this list of criteria.
So we don't have a fixed list, but rather than we have a criteria list that can be applied to.
Yes, it's a very flexible criteria list, but it nonetheless needs to be approved by FINMA. But the idea is that you as a client of a DLT exchange, you know what to expect, and you won't get any altcoin out there that just was created by someone. So everything that's traded here went through an approval process.
Thank you.
So, thank you.